So let's start with a foundational concept in English land law. You don't actually own the land itself, but rather an estate in the land. This idea immediately establishes a core distinction between holding an estate and holding a lesser right, which we call an interest.
Think of it this way. An estate is about possession and ownership for a specific duration of time. An interest, on the other hand, is a proprietary right you can exercise over someone else's property. A classic example is an easement, like a right-of-way. It's a right that falls short of actual possession. Now, the system used to be incredibly complex, so to simplify things, the Law of Property Act of 1925 streamlined land ownership down into just 2 legally recognized estates. Let's take a look at the first of these. The most extensive form of ownership is what's known as the fee simple absolute in possession, or what most of us just call a freehold. To really get what this means, we have to break down the term itself. The first word, fee, tells us that the estate can be inherited.
The next part, simple, signifies that there aren't any restrictions on who can inherit it. This sets it apart from older, more limited forms of ownership that specified a particular class of heir.
Then we have absolute. This word means the ownership is unconditional. It's not a right that's going to end if some specific event happens. For all intents and purposes, it's perpetual ownership. And finally, in possession. This tells us that the estate holder has a current, immediate right to enjoy the land. It's important to note that the 1925 Act defines possession quite broadly. It includes not just physically occupying the land, but also the right to receive rents and profits from it. All right, that brings us to the second legal estate, the term of years absolute, more commonly known as a leasehold. Now, unlike the perpetual freehold, a leasehold is defined by its finite duration. It exists for a specific, certain period of time, and when that term is up, the property reverts back to the freeholder. Okay, so we've established the 2 legal estates. Now let's turn our attention to those lesser rights we mentioned, the interests. These are divided into 2 distinct categories, those that are recognized at law and those that are only recognized in equity. And the Law of Property Act 1925 is actually very specific here. Section 1, subsection 2 gives a definitive list of only 5 types of interests that are capable of being legal. As you can see, this includes things like easements, mortgages, and a landlord's right of entry. For an interest to be legal, it has to fall into one of these buckets and, critically, be created by a formal deed. So what happens if an interest doesn't meet those strict criteria for being a legal interest? Well, the statute is clear. It can only exist in equity. This is a very broad category that includes some very common rights, like estate contracts, restrictive covenants, and, importantly, beneficial interests that arise under a trust. Okay, so now that we've classified these rights, the next logical question is, how are they protected? This is especially important when land is sold. We'll start with the modern system that governs the majority of land in England and Wales today, which is the Land Registration Act of 2002. The 2002 Act sets up an interesting 3-tier system. First, you have registrable dispositions. These are major dealings with the land, like a legal mortgage, that must be registered to be valid. Second, there are third-party interests, which are mostly equitable rights. These are protected by putting a notice or a restriction on the land register. And then there's the third category, overriding interests. These are rights that bind a purchaser even if they don't appear on the register at all. As you can imagine, this last category is a major source of legal disputes. To really understand this, we need to look at one of the most significant cases in this area, Williams and Glyn's Bank versus Boland. This case is absolutely fundamental to understanding the power of an overriding interest. So here's what happened. The legal title to the family home was in the husband's name only. However, his wife held a beneficial interest because she had contributed to the purchase price. The husband then mortgaged the property without her knowledge and later defaulted on the loan. The court held that the wife's beneficial interest, when combined with her actual occupation of the property, was enough to create an overriding interest. You'll see the rules are quite different in the unregistered system. Legal rights are said to bind the whole world, which means they are automatically binding on any purchaser. Most equitable rights, however, are handled differently. To be effective, they have to be registered on a separate register called the Land Charges Register. For the few equitable rights that aren't registrable, the old doctrine of notice applies. This means the right is only defeated by a bona fide purchaser for value without notice. Overreaching, and it's designed to protect purchasers from certain types of equitable interests. So, how does overreaching work? Well, it specifically applies to beneficial interest under a trust of land.
The key statutory requirement, and this is critical, is that the purchase money must be paid to at least 2 trustees. If that condition is met, the beneficiary's interest effectively detaches from the land and reattaches to the purchase money. This means the purchaser gets the property free and clear from that interest.
The case that really demonstrates this principle in action is City of London Building Society versus Flegg. And what you'll see is that it provides a really stark contrast to the decision we just discussed in Boland.
In this case, a set of parents contributed money to a house that was legally owned by their daughter and son-in-law. This meant there were 2 legal owners who were therefore acting as 2 trustees. When the daughter and son-in-law mortgaged the property and defaulted, the court held that the parents' beneficial interests were overreached. Why? Because the mortgage advance was paid to 2 trustees. The parents' right was detached from the property, attaching instead to the mortgage money, which left the building society free to repossess the house.